All right. Well, thank you all for attending the second in a series of webinars we hope to have. And today's topic is compensable injuries at home. And our panel is Steve Tregay from Chartwell, who practices Maryland Comp along with me. Commissioner Jeffrey Weinberg, who's, Your Honor, are you of counsel at Warnken now?
Yes, I'm of counsel at Warnken,
All right.
and also a mediator as well.
Yes. And then we have Jim McAllister at Cohen, Snyder, Eisenberg, and Katzenberg. And I pronounced your firm correctly this time, Jim. So thank you all for participating today. Thank you all that are attending. And it's a pretty timely topic for everyone because I saw on Facebook yesterday that the New York office of Chartwell did an article on a case in New York where the administrative agency tried to limit at-home injuries, and they tried to use language limiting at-home injuries to injuries that occur during regular work hours while performing work. And at the appellate level, that language was struck down and said you can't limit at-home injuries to that restrictive definition, that you had to use the regular case law from New York in addressing at-home injuries. So the standard in Maryland is an injury is compensable if it arises out of and in the course of employment. And the cases deal with the arising out of portion, establish a standard that there has to be a connection between the injury and the employment. And then when you look at the in the course of employment, that standard seems to be related to time, place, and circumstances of the work injury. So we're going to address a couple of Maryland cases that set the stage for the standard, and then we'll look at a bunch of fact patterns, and then we'll have some questions. But to go off topic, I wanted to address an interesting issue that Frank Young from Johns Eastern raised a couple weeks ago, and it's a jurisdictional issue. Maryland is a little squiggly little state, and lots of people that work in Maryland live outside of Maryland, and there may be an issue that a Maryland company that has remote working folks from home are actually working in Pennsylvania, and whether that Maryland company has coverage for a Pennsylvania work injury because the injured worker is working at home in Pennsylvania and not in Maryland. And Jim, you just did an outline on that. You want to add anything to that topic?
Certainly, what people, many of you are in the insurance industry, so you may know that workers' compensation is a state-specific policy. So you buy workers' comp for Pennsylvania. You buy workers' comp for Maryland. So that if an injury happens that's covered and is within the jurisdiction and a claim gets filed in Maryland, and you only have Pennsylvania coverage, then you have an uninsured claim in Maryland. And the consequence of that is the uninsured employers fund pays the claim and then seeks subrogation from the employer. And what I have not seen, in especially workers' comp, is the equivalent to what we see in rent-a-car cases, which is called a multi-state endorsement. And I think that may be the product of, or maybe an outcome of people working remotely, is you will now have insurers issuing multi-state endorsements so that in the event you have a Maryland, let's say a lawyer who, lives in Pennsylvania, works in Maryland, but gets injured, while logging in remotely from his or her home office and files a claim in Pennsylvania, the law firm they work for in Maryland may not have Pennsylvania coverage. So, and as Commissioner Weinberg pointed out when we were preparing yesterday, you can have an injury that results in workers' compensation jurisdiction in more than one state. So, for instance, you could have an employee, that same scenario I gave you, that employee would probably have the right to file a claim in Maryland or the right to file a claim in Pennsylvania. You can't recover twice, but it presents the potential of an uninsured exposure to employers who have employees working out of state remotely.
And that's just something to keep in mind. I've seen, I mean, a lot of business policies have other states' insurance coverage, but I mean, we've had trucking cases and things like that. Driving through Pennsylvania, it's a Tennessee trucker, and there's no coverage. So, um, but to get back on the topic of today's seminar or webinar, injuries at home, we have a couple of recent Maryland cases. There's the Schwann food case and the Montgomery County versus Maloney case that we can use to set the stage for various fact patterns on what's compensable and what's not compensable when you're working at home. Anyone, Steve, you want to take the Schwann case?
Well, sure. I could take the Schwann case. I don't like reading case law to people. That is absolutely boring. But I can.
Just go over maybe just the facts and
Well,
we.
I was just going to say. In fact, Um, I don't know if I have the facts in front of me. I have the holding in front of me. Um,
What the facts were basically is that it was a slip and fall in front of the injured worker's home. He was getting ready to travel to his first customer of the day.
all right.
But an additional fact is he also was on his way to visiting that customer, was going to drop off his son at daycare. So one of the defenses put up by the employer in that case was, as he was attempting to get into his car, he was attempting to get into his car to take his son to daycare, uh, and, not necessarily to go to the employer's place, I mean, the customer's place of business. So that the court disagreed with that defense, but that was additional fact that made it uh, questionable. Yes.
And Schwann was a little um, behind of where we are now because the focus in Schwann was to determine whether, in addressing whether the injury was within the course and scope of employment, was whether his home work setup or items that he had at home to do occasional work constituted a home office.
And the importance of that in Maryland workers' compensation, one of the easiest ways to have a compensable claim is the courts have drawn this very broad standard called premises. If you're on your employer's premises, it's covered. If you park your car on the employer provided parking lot and you're walking, to your employer's place of business, it's covered. So what the home office rule does is it creates premises uh, status, so to speak, at the house, and that is that's sort of where I think the courts may be going. But that's you can either say, well, it's either transactional, like he's actually trying to go to a customer, or does his home office automatically become the premises? Because if it becomes the premises, then anything that happens there is covered. So you have those two competing standards for determining whether or not it's covered under Maryland workers' comp.
And
And it's not clear from the Schwann case which one of those they went with.
that's right, because the Schwann court ended up remanding it for further fact finding because um, the items they were looking at to determine whether a home qualified as a work site was the quality and regularity of work performed at home, 2, the presence of work equipment at home, and 3, the special circumstances of the employment rendering it necessary and not merely personally convenient to work at home. So um, in our situation today, it seems like there's no question that a lot of us are working at home. Um, so I guess the next case to come up with standards for Maryland analysis is Montgomery County. Any takers for that?
I'm a non-taker.
Well, that's not an at-home injury, but that was an injury where a firefighter was asked to participate in some training in Montgomery County. He lived in Virginia, and after the training program, instead of driving all the way back to Virginia, he went to a fire station that happened to be nearby, and he ended up, I mean, it was his personal convenience to get to that fire station that was close by where that seminar was taking place because he had to participate in the seminar the following day as well. But in any case, he got up like in the night and twisted his ankle, and the court in that case determined that that was uh, an injury that arose out of and in the course of his employment. Anyone have any thoughts on that case?
Well, again, you have an injury occurring off the employer's premises, and what the court seemed to focus on, and both of these are Court of Special Appeals cases. And for those of you who are unfamiliar with the Maryland court system, the Court of Special Appeals is our intermediate appellate court. So, and the Court of Appeals has not weighed in on this issue, and that, of course, is the highest authority. But what they were looking at in that case is, did the employer know that he was staying there? Did the fire chief at that fire station know he was there? Was there a work-related purpose associated with him being there? Did it make it more convenient for him? Because they say, basically they said, you didn't have to sleep at the firehouse. You could have driven home. But, there was, he would be fresher, so to speak, at the seminar the next day because he had stayed locally as opposed to commuting back and forth from his house. So, the actual exposure had some, benefit to the employer, and the reason he was there was because of, his employment situation. So, the first thing, it arises out of his employment because, and they refer to this thing as the positional risk test because you always have to come up with a fancy label for something. But that's basically was he placed in harm's way as a result of that? And they said yes. And then they said, well, is it course of employment? Is there some occupational correlation with why he's there, what he's doing? Is his employer acquiescing in it? And does his employer know about it? And they found a sufficient occupational correlation that they found that it arose in the course of employment. So, it's an interesting case because you've got somebody hurt off the premises, off the clock, sleeping, and yet it's covered. So,
But Jim, I think another view of it is he actually was on the premises, and there was acquiescence by, I think, the fire chief, and it was not an uncommon practice for the convenience of firefighters to stay at different locations.
I wonder if he just stayed at a friend's house or at a hotel.
I was just going to ask, do you think the result changes if I get hurt at the Holiday Inn, getting up to go to the restroom in the middle of the night?
I think it depends on whether your employer has sent you there. If your employer expects that, and they call it a traveling employee, if they send you someplace like Ocean City, and pay for your hotel room, and expect that you will be staying someplace other than home, then that's generally covered. But if and here sort of the rub was he wasn't really staying that far away from his house. And the employer didn't specifically say you have to travel to a location where you're going to have to sleep someplace other than your own bed. So I think that's what made it different than the traveling employee.
Yeah, they didn't really talk about that. It's just.
It's also, I think, a step beyond the case that brought on the positional risk theory, and that happened in a hotel. But that case was clearly the employee was in the hotel at the direction and expense of the employer. But yeah, this takes it a step further away.
Yeah, that's why I was having some question on what isn't a work-related injury when you can be injured getting up during the night off, well, Your Honor said on premises, but not his regular work site.
Right, not his regular work site.
Now, how about, I guess, using those two standards in addressing whether or not something arises out of in the course of employment, going to a couple of hypotheticals, and I took these from several Pennsylvania cases, and then we'll come up with our own hypotheticals as well. But using the Maryland standard for a work-related injury, when someone is working at home, if they get up to get some coffee and end up falling down the stairs on the way back to their home office, would that be likely a compensable injury under Maryland law?
Well, I think it depends on where you go in terms of what standard are you applying to determine scope of employment or course of employment? Because if it's premises, as long as you're on the premises, then you're covered. And the problem with that from the insurer's perspective is, if you apply a purely premises standard on where at the employer's place of business, they can control, whether the oil on the floor gets cleaned up or whether there are dangers that can be abated. But in my house, my employer's locked out of the ability to reduce potential risks at my house. So considering my house to be their premises sort of puts the employer at a disadvantage in terms of abating risks. It puts them at an advantage because they're making a lot of money because they don't have to have office space for me downtown. So that premises standard, if the court were to apply a premises standard, Jack, I think it's covered. If the court restricts it to, an occupational correlation, meaning there has to be at some point when you get up from the computer, at some point you've stopped being involved sufficiently in a work-related activity. So now we're looking at what you're doing as opposed to just the site, the premises. The further you get from that computer, and we have to ask, why are they going down the stairs? Are they going downstairs to get the mail, which may have business stuff in it? Or are they going down the stairs because their kids screaming and yelling, in the kitchen? So those are issues I think that await clarification from the appellate courts.
More specifically to Jack's scenario, if someone's in the office and they want a cup of coffee, they can get up and walk away from the computer and go get a cup of coffee in the office. So in that vein, I think it's compensable.
Well, but Commissioner, do you think the commission and Maryland courts would do what New York attempted to do and wasn't successful, but to basically get rid of the premises standard when if it's applied to at-home work, it would be about as broad as you can get?
Well, Jim does a lot of legislative work. I've been away from that for more than a decade, but I can't imagine the Maryland legislature trying to limit almost out of hand all home injuries.
No, I agree. I mean, and like I said, the employer is benefiting from it. And Jack, your hypothetical says, I'm going to get a cup of coffee so I can go back to work. Whether you look at it as an occupational correlation or whether you look at it as premises, either way, that's covered. The question becomes, what happens when my kids start screaming downstairs, or, which is something that wouldn't happen if I were at the workplace. I could certainly go to the lunchroom at work to mirror what Commissioner Weinberg said. If it's something you could do at work and you're doing it at home, it seems like it should be covered. But, what happens when you're doing something, you wouldn't do at work, which is dealing with a kid, or there's a knock at the front door because somebody's delivering your Amazon stuff, those are things that the purpose of those, diversions from the employment, I think lend themselves at least to a claim that this can't be accident related because it has no relationship to something you could do in the workplace.
Well, how about if you get up to get a cup of coffee and you trip over a dog that wouldn't be in a regular workplace? What about that?
I think if you're looking at the purpose of, but at the workplace, you could trip over the rug. At the workplace, you could trip over anything. So I think, my sense would be that as long as the reason that you're leaving the hands-on employment, the active performance of work, is something that you could do in the office, then I think it's more likely to be covered, even if you look at an occupational correlation, because it really has to do with why is the employee separating himself or herself from the actual physical performance of work.
And, and I think given COVID, I think an argument can be made that there may not be what we would call a workplace at this point. If your employer is my employer is telling me, don't come into the office. We don't want anyone in there if they don't have to be in there. You must stay at home and work remotely. At that point, there may be an argument can be made that because we're using that distinction of what can we do at the workplace and what we can't. But what if there is no workplace because of COVID-19? I don't have an option of going in. I have to stay at home. I think at that point, there's a better argument to be made, at least as far as COVID is concerned, that my home is at my office at this point. So if I do trip over that dog, you know what? That is part of the workplace at this point.
And that's sort of similar to sending me to a hotel in Ocean City, because you're requiring that I be at a location, and in order to do your business. So that's a great point.
And I happen to be in a situation where my employer came to me about a year before COVID started and said, would you like to work from home? Because in all frankness, with what we do, I'm on the road all the time. So it was more convenient for me, in all frankness, to be able to be based out of my house sometimes. If I'm going to Philadelphia to do something, I live in Lancaster. The one office I'm associated with is actually in the Harrisburg area. So it would be much more convenient for me to do something in Philadelphia and come home rather than going all the way back into the office. And then COVID hit, and we were required to be here. So I think there'd be a distinction there if I'm doing something at home because it's my convenience. And yes, my employer's asked me to work from home, but if I trip over that dog versus, hey, we don't want you in the office, we don't want you here, and you have to do it from home.
Wonder if the office is shut because of the government mandate.
I think, yeah, I would agree. Exactly. If the office is, well, that's a good question, Jack. That's an excellent question. If the governor is telling you you have to stay home, how does that change things?
I think you're still doing the employer's bidding, and your employer has two choices: they either close or stay open. Well, if they stay open, they're requiring you to work from home because they lack the ability to have you work anyplace else. So
And
I think that's an interesting question, Jack, but it wouldn't change, my conclusion, but it is an interesting point.
well, if you're looking at the purpose of the activity, and that fact pattern in terms of falling downstairs, getting a cup of coffee, just brings up the importance of getting early statements and to defend these claims, to find out, what the circumstances were when this injury occurred at home. The employer doesn't have any control over the at-home work environment.
Yeah, I agree with that, Jack. I think, every one of these cases is so fact specific. And the more facts we add, it's going to change, I think, your ultimate analysis. And I'm actually dealing with something, it's actually a Pennsylvania case, but it's sort of that same situation where we have a claimant who had a work vehicle. There was a shop that they went to maybe 70% of the time rather than going directly to a job site in order to get tools, in order to be told by a supervisor, this is where you need to go to next. And of course, he is injured while driving the truck to pick up a pallet. And the question becomes, I think, whether or not he was told by a supervisor to go to another site and pick up that pallet. And when we talk to the supervisor, we're told, I'm not sure what I told him. I have no idea what I told him. So then it becomes whether or not the pallet was needed specifically to do the job he was supposed to do. So getting statements quickly and preserving all of those facts, because every time you add a fact to one of these patterns, it could change the ultimate analysis.
Yeah, I mean, as a trial lawyer who's lost many a workers' comp case to a well-prepared employer who had statements, or the other thing is look at the medical records. If these individuals go to a doctor, they may say things to the doctors that, well, I'd logged off the computer and I was, going downstairs to take my kid to the doctor, and that almost cost the claimant in the Schwann food case his claim, because the argument was, well, you were taking your kid to daycare and that was specifically what you were doing at the time you got hurt, not going to see a customer. And they said, well, that was just a stop along the way, and it wasn't a big deviation. But those are the sorts of things you learn sooner that nobody will remember later on.
And that's we got just a question about handout materials. We can send some handouts to everyone. There is a blog on our website, Chartwell's website, on this topic as well. So, but moving on, in terms of the purpose, there's also how about an injury at home when you're using the restroom?
Well, unless you're in a barbaric work environment, that's something you should be able to do on the job. So, and if the testimony is I got up to use the restroom and I was going to come back and use the computer, that's something that certainly could have happened at work. Assuming you have a restroom at work, and I'm assuming we all do. So,
How about if you have an outhouse in your farm?
well, for our Amish friends, I would say,
Well, yeah. No, I have indoor plumbing, thanks to the. But yeah, I think, Jack, some of that comes back to, if it's the middle of 11 o'clock in the morning, I'm in the middle of drafting a brief while I'm sitting here, and I realize I need to use the restroom, and I get up and I hurt myself. I think that's what the courts would call a momentary diversion. That's not unusual. I think if I've logged off at 6 o'clock for my employer, 8 o'clock at night when I normally log off because I work so hard. I finally log off and I'm going to do something else. If I'm going to get the kids dinner or sedate them, whatever I need to do at that point, and I hurt myself doing that, I don't think I'm furthering my employer's interest. And I think that if it's the end of the day, I'm no longer furthering their business in any way, and it's no longer a diversion. I've moved on to a different task at that point, i.e., making dinner.
But working at home does sort of blur, the time and space kind of limitations for work injuries. Jim, you pointed out answering emails at 11 o'clock at night and things like that. How do you're not actively working, perhaps you're not at your computer, but maybe you're on your phone answering work emails and something happens and you have a work injury. Is that a compensable injury, or are you off the clock at that point?
Well, the Swan case distinguished that. They said the first question you ask is that your home office? Because if that's your home office and you're working from home, then that would be compensable, which lends itself more to a premises standard. And it distinguished cases where, at 10 o'clock at night, you're just checking your email or something like that. But that doesn't make it your home office. There are cases where people have taken work home and done work. That doesn't make it your home office. So the court seems to be distinguishing between somebody who checks their email or maybe logs in, at night to do a little extra work or catch up on something, versus if it's your home office. In that scenario, if it's your home office, and that the answer to that question is yes, then it's more likely to be compensable, even though it takes place at 11 o'clock at night when you're checking email. If it's not your home office, unless you are holding the computer and it blows up in your face or something, if you're not actually transacting business at the time you're hurt, if it's not your home office, I don't think it's going to be covered.
Well, how about, does it make a difference if you have a home office, like a space, a room dedicated to work, or like folks like me that I'm sitting at my dining room table? I mean, where is the limit on my home office?
Well, I think it comes down to, are you an employee who works from home? There's a difference between an office, which has four walls, a desk, and a chair, and your principal place of business. Where do you work? So if you have a room carved off in your house with a desk and a chair, but you work from an office in downtown Baltimore every day, and you come home at night and spend a little time in that office, I don't think you're going to qualify under the Schwann case as a home office injury.
I agree with that, and I think another analysis is the emails at night. if you do have a regular place of employment where you go every day, you leave home, you go to the office, but at night you're reviewing the emails, that's the same thing, I think, even if you have the home office authorized by the employer.
And I think that brings up a point. Like if the employer says, okay, you know, Jim, you can put a printer in your house, we'll pay for it. We're going to wire your house for cable. We expect you at night to spend an hour in that office working on something. Or we may need to contact you. So you have to set aside a space, and I trip over something in that specific room. I think that's a lot more like the firefighter, you know, who's at a place that the employer knows about, has authorized, and maybe even instructed me to create. And that's going to be much more likely to be covered versus for my own convenience, unknown to my employer, so that my kids don't get in and wreck stuff. I set aside a room that I'm going to call my office, but I still commute to Baltimore every day to practice law.
But if you don't have that kind of space available in your dining room table, where do you have the limitation between a home office workspace versus a living space or anything else?
Well, I think it goes back to, is that your principal place of business? You know, is that your quote unquote office? Like right now, I'm talking to you from my office in Baltimore. Okay. So if I go home tonight and sit down at the dining room table and answer some emails, you know, that's not my home office. So it's not, you know, it's not the room. It's the, you know, it's, you know, where do you work? I work here,
How
you
about
know, and answering, you know, incidental or occasional work at home doesn't make that a home office, as the Schwann case seems to say.
well, how about similar. It's the personal comfort doctrine that's gone to the restroom and things like that. Getting a cup of coffee. How about working and you take a moment to jump up and hit the rim of a basketball hoop just to blow off steam for a moment while you're working. Would that be compensable?
I think you have to look at the deviation standards. You know, how far off of the work did that take it? You know, an employee, I think the Court of Appeals case that talks so much about that is where an employee went to go see something that the employer had done some construction or something in another part of the building and had on their own without any authorization, just wanted to see what was going on in that part of the building, had an injury on the way. And as I recall, that was found to be a deviation that was not compensable. Jim, do you remember that case?
Mm-hmm.
Yeah, and when you look at and now we're talking about course of employment. At what point does an employee do something that takes them out of the course of employment? So in other words, you know, it's called deviation or horseplay. You know, there are things you can do that interrupt the occupational correlation. You know, and if the guy is walking into, you know, is carrying stuff in and out of a house and for a moment jumps up and tries to touch a basketball hoop, I think that's probably, he hasn't really deviated from the employer's purpose that much. It's not like, you know, you sent me on a mission to Philadelphia and I got hurt in St. Louis. You know, that's a deviation that took me way out of the scope of employment. But if I stop off to see my grandmother on the way who's 1 mile off of 95, you know, generally that's not considered a deviation that takes you out of the scope of employment. So, I mean, we're allowed to take breaks and still be in the scope of our employment.
How about and that was a Pennsylvania case. It was found compensable by the court. Just jumping up and to hit the basketball rim after your last delivery of the day.
And Jack, if I was going to say, if I remember that case, I think one of the reasons it was found to be compensable because he didn't jump up and then tear his meniscus when he fell down. He suffered a catastrophic brain injury when he came down, and I think that was one of those cases where, yes, the court found that it wasn't a deviation, and that quote leisure activities are sometimes occur during the course of the day. But I really think what was driving that was the extent of that injury in that case.
Well, how about for a police officer, you go home after the end of the day and you shoot yourself while you're cleaning your gun?
Unintentionally shoot myself while I'm cleaning my gun?
Would that be a compensable injury in Maryland, that if you're at home cleaning a gun after your workday?
I mean, there's case law in Maryland that says if you're an off-duty police officer, you're almost always considered to be in the scope of your employment because, you have policing privileges that don't end at the end of the workday. Plus, you're cleaning your gun. I assume the police department assumes you will clean your gun. And I'm assuming it was a service revolver or firearm that was provided by the police department. If he's cleaning his hunting rifle, I don't think it's related. But, if it's, the purpose of that is to benefit the employer, and I assume the employer has instructed him, you better clean your gun. So I think that'd be compensable.
Another question is, and we talk about personal comfort, where's the limitation on restricting compensable injuries to events that don't include eating lunch, eating breakfast, eating dinner, or eating a snack?
Well, I think the two things come to mind. Number one is, are you still on the employer's premises? Because if I get up from my desk here, as long as I'm on the employer's premises, unless, I work in some building where, I walk, a mile to the next campus or something for a purely personal mission, it's tough to leave the scope of your employment because keep in mind, all of this is designed to identify whether by virtue of the employment relationship, you are being exposed to a higher degree of risk than the public in general. So that's why they say as long as you're on your employer's premises, the public isn't exposed to those types of dangers, and therefore it's more likely to be covered because it's something unique to the employment.
So if you're at home and your home is your home office, or injuries are compensable if you're eating any time of the day?
Again, like I said, it depends on where the courts go with the standard, because if it's a premises standard, there are cases where an employee shows up to pick up a paycheck or to check a schedule on his or her day off, not on the clock, and that's deemed compensable. So, premises is very broad. And if premises was the only thing that Schwann needed to win, then the court would not have had to discuss whether or not he was taking his kid to daycare or not, because premises would have automatically been covered. So that suggests the court didn't buy a premises standard 100%. So, I think it's going to be a much more task-based focus. And at some point, and I'm not sure anybody knows when that point is, your workday is over and you're now off, outside the scope of employment. But, there's going to have to be some delineation as to when that is. Like, let's say I work 9 to 5 here every day. Well, if that's your average workday is 9 to 5 and you get hurt at 9 o'clock at night in your house, I think there's a persuasive argument that that's not covered. But, if it's 10 minutes after you log off, perhaps a different story. If you're getting up to walk to another part of your house to do something unrelated to work, aren't you a lot like an employee walking to your car in the parking lot at the employer-provided parking, which is compensable? So I think the occupational correlation standard is something that we're all going to be focusing on to determine at what point the employment light goes out and the off the job light comes on.
Well, should employers be telling at-home workers when they're working and when they're not working?
I think that's brilliant. I mean, you have to basically identify, and I think an effort made to identify what is and is not the workday. Now, the Workers' Comp Commission and the courts have the ability to look beyond, or look behind those sorts of things. But I think a correlation or tracking of when the employee is working and when they're not working, and you should log off at 6 o'clock. If you're going to work past 6 o'clock, you've got to get somebody's permission.
And
I
that's
think
like whether or not an injury is compensable when you're in the car using a cell phone on a work call when you've been instructed by your employer not to use handheld devices while driving. Putting that.
well, good.
Oh, please go ahead, Jim.
Well, this comes down to something called the going and coming rule. Ordinarily, commuting is considered not compensable because we're all placed at risk by being in a car and driving somewhere. And so therefore, there's no unique risk associated with commuting, that makes you, so the going and coming rule has been very clear that it's outside the scope of employment. So what happens when I'm working from home and I'm driving to a client's place of business? Is that scope of employment? And, what if I'm using a cell phone? What if the employer pays for the cell phone? When you get to disobeying an employer mandate, like if the employer says, don't use the cell phone in the car, the first question is that trip compensable otherwise? Because now you're dealing with willful misconduct. And normally the willful misconduct has to cause the injury. So if you can show the employee was texting at the time he or she rear-ended a bus and that caused the injuries, then the willful misconduct, would be a defense. But if it's just, hey, you broke some rule at some point while you were in the car, I don't think that would be a defense to the claim.
How about we have a good question that came in. With all of these at-home makeshift work setups, what about developing carpal tunnel syndrome due to increased all-day-long computer work at a makeshift home office workstation?
I think that's just going to go back to the causal relationship. If it's overuse and it's clear and it's medically connected, why not be compensable? It doesn't matter whether it's at home or at work, and whether the employer provides an ergonomically appropriate setting at home or at the office. It's still in the course of employment, as long as it hits all the other elements of an occupational disease.
I agree with Commissioner Weinberg. I mean, as long as you can show, an occupational disease, which is an overuse associated with the work. Because keep in mind, just having a problem isn't enough. You have to show that the work, and again, it goes back to that, did the work cause you some increased exposure to a risk that the rest of the general public isn't exposed to? Well, the rest of the general public isn't sitting there for 8 hours a day typing away. Now, an interesting case came down last year involving a firefighter, because, and this is a little bit off topic, but it discusses what do you have to prove in terms of overuse. Do you have to prove that Jeff Weinberg were typing for 8 hours and that overused your carpal tunnel? Or can you show that all people who use keyboards have a higher incidence of carpal tunnel, and therefore, if you are engaged in a profession where you're using a keyboard, you can meet your burden of proving occupational relationship, which is it's interesting. But I assume you use your keyboard for other reasons at home. But if you're using it for 8 hours a day, I agree with Commissioner Weinberg. I don't think it matters where it is.
We have another question that came in in terms of the time limitations. I think it deals with fact-specific circumstances. That the question is, what if you were an exempt employee and there are no set hours that you work because being an exempt employer, you were there to get a job done no matter how many hours it takes Doesn't matter what time you injure yourself. Should that be covered?
You mean somebody who's, not exempt from the 40-hour work week?
Yes.
Like somebody who's in management or like a lawyer?
Or a claims adjuster working at midnight sending out emails.
Well, I think it goes back to the question or the comment you made earlier, which is, you know, when does the workday end? I mean, if you're required to work or be available 24 hours a day, like a police officer, that's more likely to be covered. But if you are given a certain workload and you're doing that workload and that workload stopped for that day, and then 2 or 3 hours later you trip over the dog, I don't think being an exempt employee renders that compensable. I think it goes back to an occupational correlation between what you were doing and when you got hurt.
It's almost like the meals thing you were talking about. I think a factor to look at is what were you doing before, and is it expected that you'll be back at work after? For example, if it's a 9 to 5 worker, you asked about dinner. If dinner is after 5 and they're injured with that, and they're not going back to work, then clearly that's not compensable. But a lunch hour is often provided. If it's on the clock, it's clear. But otherwise, like the lunch meal, there's work before and there's work after. It's just a continuation of the course of the day. So I think that's part of the analysis.
And unless anyone has any additional fact patterns, I had a question on the going and coming standard in Maryland. And going back to that, and Your Honor, maybe you can pronounce that case I was talking about in the mid-1990s, the Alitalia case.
Yes.
We were, oh, go ahead, please.
No, go ahead.
No, we were discussing a little bit about that before we started this webinar today, that I viewed that as having an exceptionally broad standard in Maryland for an exception to the going and coming rule when your employer requires you to have a vehicle available during work. But was that case limited to those facts where the employer had a rule, basically, or a directive that as a condition of employment, you have to have a car available, as opposed to just needing a car for work to go to hearings or to visit customers or things like that?
My recollection was it was very specific to the requirement by the employer that the car be available in case any kind of work outside of the office was required. Then the car was right there; it was available. But I think it was a very limited slice of fact there.
Because otherwise, it would sort of eat up the rule. The exception would eat up the rule because most of us require a vehicle to be available during work hours.
Well,
Go ahead, Jim.
Well, the interesting thing, and Jack brought this up when we were preparing for this, is what does that do to the going and coming rule? Because in the Alitalia case, the employee was sort of like an on-deck guy. So, at any moment he would have to run, almost like an EMT. He would have to jump out of his car and go someplace to do the employer's business. So he had to be like a responder. But theoretically, if I'm a lawyer and, I have to go to court oftentimes and be in 2 jurisdictions at workers' comp on the same day, let's say Abingdon and Beltsville, isn't my employer putting me into the position of the claimant in Alitalia? Because there's no way I'm taking the public transportation out to Abingdon and then to Beltsville. I'm required to have a car and they don't pay for it. And of course, if the employer pays for it, then it becomes more likely covered. But if I'm commuting, when am I in the course of employment? Not. And the notion of commuting has changed now because we're working from home. Because, under the old standard, if I drove to my office in downtown Baltimore and then I got, a file and went to the courthouse, commuting to the firm wasn't related, but going to the courthouse was, because I'd started my workday. Well, my workday theoretically now starts when I leave my house and go to court, because I don't go to the office because my office is closed. So, I think that's going to be an area of a lot of debate is when does commuting turn into something that's compensable because you're not going into the office. What do you guys think about that?
Not
Well,
sure.
well, I was, as you were bringing up that topic, I was almost wondering if there would be a benefit to employers to have official office workspace available. And then if you happen to be working at home, that's your own personal deal rather than working in the assigned office that the employer has available for you. Does that make a difference?
I think under the Schwann case it does, because you're now working for personal convenience. Now, there's such a thing as a pretextual, if there's one office for 300 employees and everybody's working from home, it starts to look like, it was done as a pretext in order to prevent their home from being considered a home office. But Jack, I think that's, that is a good observation. But then the employer now has to, pay for downtown office space and all the expenses associated with that. So, there's going to be a sorting out economically once this COVID problem is solved as to whether employers think they do better economically paying for downtown office space versus, the free space they get in my house.
Jack, under that circumstance, though, it sounds like the employer is giving an option to the employee. We're providing the space. We'd like you to come here, but you can choose to work from home. And then that, you go back to all the factors as to whether the home is the premises.
I agree with Jeff. I think if it's optional, that doesn't change the outcome. It only would defeat home office if they say, we have an office for you here, we want you here, but you can, if you choose to work someplace else, then, that's your problem, but there's still going to be an office for you here.
And that's probably the case now, but Jim, you think that things are going to change as leases are up for renewal?
Oh, all my friends that work at big downtown law firms, and I have, local vendors and restaurants and, place, around the corner that has fresh grilled nuts. And all of them are scared to death because everybody is saying, once our leases come up for renewal, we're not renewing our leases. Now you'll have a conference room, a mail room where stuff is scanned and, uploaded to a server. But, in terms of having, 100 lawyers in a law firm, each of whom has their own personal office on several floors of office space, I don't think that comes back.
Well, actually, we have a couple of minutes left if there are any other questions. I thought, Steve, you raised your hand, and I was going to.
No, sorry, I was not. I was looking at a note. Did not raise my hand.
Well, I guess we'll end a couple minutes early if there are no questions, or unless anyone has any other points you want to bring up.
Well, I would just say, this is an evolving area, and the ability to, get in front of this and deal with these issues ahead of time, it's the ounce of prevention versus a pound of cure. I think several important things have been said here today. Number one is, the employers need to set some sort of limits or, control over when the employee is working and when the employee is not working, and make that clear. Number two, check your comp insurance policies. Make sure that if you've got out-of-state employees working remotely from Maryland, that you have sufficient coverage, because you could wind up with a dual jurisdiction. And keep in mind, once the uninsured employers fund in Maryland pays, they then go after the employer for reimbursement. So that's a problem. And there are also criminal penalties associated with not having comp insurance. And the other is, driving, commuting to and from, why is the employee going someplace? Where are they going? The going and coming rule, is something, and it's important that employers and risk managers get behind who's doing what. How are we dealing with this? Are there limits on it? Because the limits that you place on it may or may not be ultimately accepted by the workers' comp commission or the courts, but the limits that you don't place on stuff are going to, you don't get an opportunity to control the risk at all, because you're basically just saying, okay, work whenever you want, do whatever you want. And by doing that and deputizing employees to basically work whenever they want, do whatever they want from home, you're creating two problems. Number one is a broader scope of employment. And number two, again, a point was made earlier. You don't have cameras in these people's houses. You don't know what's going on there. And without, getting some sort of understanding with, your risk managers and your comp adjusters and comp underwriters of what is and is not work related in that home, if you have no controls or no standards or no limitations whatsoever, I think you're going to walk into a propeller called workers' compensation. Because keep in mind, workers' compensation is remedial legislation, and the legislature has said a tie goes to the employee. So one of the ways that you can hopefully control that is to do something now, as opposed to, defensively responding to something later.
Well, that's it. When you said there might be dual jurisdiction, I was hoping that remains the case, because the longer this pandemic lasts, the less likely there's going to be Maryland jurisdiction for an out-of-state injury, since you have to be regularly employed in Maryland, and that may not be the case for a while. So,
Well, Jack, let me just say to that. Am I employed in Maryland if I'm logging into a Maryland server for a Maryland law firm who hired me in Maryland, but I live in Pennsylvania? So I don't think you can necessarily assume that doing business with a computer in Maryland that sends out emails from that server in Maryland, that automatically I'm considered a Pennsylvania and not a Maryland employee. I don't think Maryland is going to roll over and say that makes you a non-Maryland employee. I think, the fact that you're logging onto a server, doing business, sending out letters that say Cohen, Snyder, Eisenberg, and Katzenberg in Baltimore. If I'm in Pennsylvania writing those letters, but they're going out remotely through my Baltimore office, I would not want to be an employer and assume that automatically makes me an out-of-state claimant.
boy, that's an interesting point. Not to get off topic, because I was thinking as you were bringing that up, the jurisdiction depends on where the server is. Some businesses might be having employees in India, but a server somewhere in the U.S. Or I believe Chartwell, one of the IT folks, lives in Puerto Rico, but works on computers that are, I guess the server would be based in the Philadelphia area. So that's an interesting point, whether we have jurisdiction and depending on where the server is.
Well, in my scenario, we're located in downtown Baltimore. Everything that goes out from downtown Baltimore. So if I log on from a remote location in Pennsylvania, I don't think that's the same as, it was routed through a server somewhere. I'm working for a Maryland employer, and the only thing I have not done is physically set foot in the state. So I was hired in Maryland. I'm employed in Maryland. My paychecks are issued from Maryland. It's more than just the server. So,
Well, we're at our time limit, but thank you all for participating on the panel, and thank everyone who chose to log on and listen to us chat about injuries at home and other topics. And I'm hoping you all agree to do another webinar sometime within the next few months. So I appreciate the camaraderie well when we're all living and working from home. Have a great day, and
All
thanks.
right, folks. Take care.
Yeah.
Jack, thanks again for putting.
Thank you for inviting me.
Thanks.
Yeah. Take care, everybody.
See ya.
Bye-bye.